Welcome to our series Lawyers, a byproduct of our YouTube channel, The Noble Litigators. Today, I'm Advocate Upasna, Legal Associate at the Law Offices of Kumar VIVEK Tanwar, Advocate and Associates. We'll discuss some FAQs on the will. So first of all, what is will? Will is a legal document where a person sets out how they would like their property to be distributed after their demise. And the person who makes the will is known as testator. Now, is it necessary to make a will? After the demise of a person, often complications and disputes may arise between the legal heirs over the property, where no will of the deceased can be found either due to the absence of the will or on account of will not being traceable or existence of more than one will. In such cases, properties and assets earned by a person during their lifetime can be lost to their children, intended beneficiaries, and legal heirs due to the absence of this simple legal document. Thus, it is advisable that every person who has the legal capacity should make the will. If we talk about the language, a will requires no technicalities of any specific language or words. Any language which is understood by the testator may be used, but it should be unambiguous and clear. Now comes to the question, who can make a will? Any adult person can make a will who is of sound mind and who is not under any sort of coercion, undue influence or fraud. Now, what are the steps required to make a will? A will does not require any particular format, and the document of will should be signed by the testator. It is required to get the document attested by two witnesses. There is no need for the witnesses to read the contents of the will. Will being an important document, it is advisable to keep in mind certain points. First, the will should be specific, detailed, unambiguous, and not vague. Second, a will should include all the intended beneficiaries. And third one is, remember to dispose of everything you have and make sure that all your assets, whether movable or immovable, tangible or intangible, are listed and distributed properly. Fourthly, do not forget to appoint an executor. Fifthly, do not forget to revise your will, especially when some important changes like marriage, divorce, or parenthood has become part of your life. Last but not the least is to have a valid witness. Now, who can be the witness? It is recommended that the witness should be independent, that is, they are neither beneficiaries and nor the executors. For being a witness, a person should be an adult, that is 18 years of age or more, should be of sound mind while signing the document, and should be able to confirm visually, and prefer if the witnesses are younger than you, as it will increase the probability of their presence in case will is questioned after your demise. Now comes to the question whether it is required to register a will. In India, the registration of will is not a mandatory requirement. It depends on the complexity of your will. If you feel the chances of disputes are high, you should go for the registration of the will, as this procedure becomes an evidence to the fact that will is made by you with the free consent. Now the last question arises is that, can we amend the will? Yes, we can amend or modify the will. Moreover, there are no restrictions as how many times we can amend the same, but the last will made by you will be considered, while the previous ones will be treated as overwritten. Alternatively, instead of rewriting a will, a codicil may be executed for the purpose of adding, altering, or explaining the disposition stated by the testator in their will. That's all for today. I hope you all have liked our podcast channel. If so, then do please subscribe our channel, The Noble Litigators. You may ask questions, can suggest us for further improvements, and for any further query, you may contact us on our website advocatetanwar.com. Thank you and have a good day.